Welcome, everyone. This is the MCLE that we are presenting. We are the Sustainable Economies Law Center. This event is called the Nonprofit Killer Bill and How It Might Affect Our Clients. This will provide 1 hour of general credit. This slide is wrong. There's just a typo. This is just a general credit MCLE for 1 hour in California. And we are covering what HR 9495 is, the consequences of suspended organizations and other implications, and how fiscal sponsorship are also impacted. We will be sharing some resources at the end, including our template legal compliance checklist. There will be a part 2 and possibly a part 3 to these series that will cover nonprofit asset protection strategies, successive organizations, alternative structures, and mutual aid. Thank you so much for attending. And throughout the presentation, I'll be including a link to the sign-in sheet for those lawyers who need MCLE credit and the certificate and an evaluation form. So I'm going to let Mo introduce themselves and then have the presentation begin.
Thank you. And just checking that the right slide is showing right now.
It is the Nonprofit Killer Bill.
Okay. And yes, so as many of you probably already know, HR 9495 passed the US House at the end of November 2024. It stalled in the Senate, but it may be reintroduced this congressional session. And so that's what this training is oriented towards. Giving people information for if it's reintroduced. It would have to be reintroduced in both the House and the Senate this congressional session, and just getting people ready if that happens. So the act is titled Stop Terror Financing and Tax Penalties on American Hostages. So in classic form, it tacks on tax relief for Americans held hostage, with giving the Treasury greater leeway to target nonprofits. So specifically, it expands Section 501(p) of the tax code to include a new designation called terrorist supporting organizations. So yeah, you might not have heard of the Section 501(p) before. It's another section of, nearby to 501(c) that is probably more familiar. 501(p) regulates alleged terrorist activities done by tax-exempt or nonprofit organizations. It was introduced as part of the War on Terror in the Military Family Tax Relief Act of 2003. And so there's basically 7 sections of it that currently exist in law already, meant to prevent tax-exempt organizations from financing terrorism. And 9 organizations in those last 22 years have lost their charitable status due to this law. So yeah, it's only 9 orgs that have been subject to the specific 501(p) revocation of tax-exempt status. And so yeah, basically, if under the current law, if the Secretary of State or Treasury deems a 501(c)(2), C3, C4 organization to be a terrorist organization, its tax-exempt status is automatically ended. That means no charitable deduction is allowed for contributions to a suspended organization. And compared to the ordinary process required to revoke a nonprofit status, there is little opportunity for notice, cure, or appealing that decision. And that's all under existing law. And so just to kind of introduce this framework as it exists already, I thought I would start by just kind of highlighting the 3 main categories of terrorist organizations that are identified as, if you meet any of these 3 categories, your tax-exempt status would be revoked. So specifically, if you're a foreign terrorist organization, that's the kind of first category. That's a category, that's a kind of designation status created by the Immigration and Nationality Act that that highlights foreign organizations engaging in terrorism or terrorist activity that are a threat to US nationals or US national security. So in order to be a foreign terrorist organization, the Secretary of State must designate you in consultation with the Attorney General and the Secretary of Treasury. And so far, 70 organizations have been designated as FTOs as of a month ago. And then, as some of you may have seen, 8 cartel organizations were added to the FTO list about 2 or 3 weeks ago by Trump. The next category is this category of specially designated global terrorists. It applies, so that category could apply to individuals or organizations, and it's a much longer list, hundreds or thousands of names on it, that are all subject to global sanctions of some sort. So basically, once an individual or entity is listed as an SDGT, specially designated global terrorist, their assets are blocked. And unless otherwise authorized, we'll get into more about what that means, but no US person may engage in any transaction with them or deal with them, including giving them funds, goods, or services. And this category was created by an executive order, 13224. It was signed in 2011 in September, so right after 9/11, and it was written very broadly, and it basically like it allows them to designate anyone who's like supporting or otherwise associated with foreign terrorist individuals or organizations. So it's a pretty broad like language because I mean it was September 2001. They weren't writing very specifically or narrowly. President Bush at the time. So yeah, it is like a an expansive category. And then the third category, again in current law, is also relatively expansive in that it's a catch-all for future executive orders that may name organizations engaged in terrorist activity defined in law. And so if other organizations are also named as terrorist organizations according to the definitions in an executive order, then they could also have their tax exempt status delisted. And so the takeaway from all of this is that existing anti-terrorism legal frameworks are already very broad, give the federal government lots of avenues to crack down on terrorist supporters. That's what we were saying with 13224, the executive order. And there's also a host of other laws that we don't talk about, like the Patriot Act, the Bank Secrecy Act, anti-money laundering laws, and more that also relate to that. And I'll pass it off to Ari. I can keep sharing my slides for you if you'd prefer, or
Oh, that'd be great. Thanks,
okay,
Mo.
great.
Great. So as Mo said, HR 9495 would add an additional category of terrorist organizations, and that's the terrorist supporting organization, or TSO. And TSO is defined as any organization that the Secretary of Treasury designates as having provided within a 3-year period material support or resources to an organization described in paragraph 501(p)(2). That's the list of terrorist organizations that Mo just mentioned. So some notable aspects about this are that it's the Secretary of Treasury who has the sole discretion to designate a TSO. As Mo described above, the terrorist organizations are often designated by executive order or by a combination of the Secretary of State and the AG and Secretary of Treasury. There's no mention of what kind of evidence the Secretary of Treasury will be relying on or what the standard of proof will be. And there's also this 3-year look back period. So they'll designate you as a TSO and they'll be looking back at the previous 3 years for where you provided quote unquote material support. And then the key component of this legislation is the definition of material support and resources from section 2339B. This is that definition. It's defined as providing property, services, including financial services, lodging, training, expert advice, personnel. As you can see, it's quite expansive and notably can encompass many things that aren't done in furtherance of quote unquote terrorist activities. To spell out an example, so as Mo mentioned, the administration has added 8 new drug cartels to the list of foreign terrorist organizations, and this could implicate nonprofits that provide services to immigrants that may have interacted with cartels. So, say, for example, you're a nonprofit who provides housing support for an immigrant who paid a cartel to come to the US, or someone who has an MS-13 tattoo. That could potentially put the nonprofit in the category of having provided material support to a terrorist organization. We've spoke to a lot of organizations who are concerned about being labeled as terrorist support organizations for expressing support for Palestine. Material support is not supposed to include pure political speech or independent advocacy. This is a quote from Holder versus Humanitarian Law Project, which is the key Supreme Court case on this topic. And as you can see, they say that section 2339B covers only a narrow category of speech, that is speech that's done under the direction of or in coordination with foreign groups that the speaker knows to be terrorist organizations. The court in no way suggests that regulation of independent speech would pass constitutional muster, even if that speech benefits a foreign terrorist organization. So the court makes a distinction between speech that's advocating for a terrorist organization or for the viewpoint of a terrorist organization, which is okay, and speech that's made in coordination with a foreign terrorist organization, which is not okay. The distinction is vague and largely undefined, but it does hinge on this being a tie to working in coordination with a specific foreign terrorist organization. And given the murkiness of this distinction, the Department of Justice has not wanted to push the line of prosecuting people for pure political speech. We don't know of any court case that have relied on speech alone to charge someone with material support. And I will pass it back to you, Mo.
Okay, thanks. Sorry, I was struggling to find the unmute button. I just wanted to, in a similar vein, kind of address this question of the scope of HR 9495 and basically name that there is some ambiguity about, yeah, like this daisy chaining concern that I'll address, and it's another kind of gray area that our partners have identified. So the situation is like, yeah, let's say this law passes and there's this new category of terrorist supporting organizations. Does that mean, like what happens to the people or organizations that supported those TSOs? So these are like the terrorist supporting organizations. Are they also at risk, or it could be like captured or threatened by HR 9495? The answer I lean towards is the first one, which is that HR 9495 says the Treasury Department must name a terrorist organization that you provide support to when it's designating you a TSO. And so that means that the IRS couldn't name a terrorist supporting organization that you supported. Like that's not like what the text of HR 9495 says. It doesn't say that like you can't support TSOs. It says you can't support terrorist organizations. So on the other hand, there is this ambiguity around like whether the groups that are marked as terrorist supporting organizations would get added to like other designation lists, like the list that we were saying, this specially designated global terrorist list, in which case supporting that organization in the last 3 years would also jeopardize your nonprofit status. And so, yeah, we want to name the kind of ambiguity in the way the law would be actually executed, and also just name the kind of real like due process concerns that would arise if HR 9495 were used to criminalize terrorists supporting organizations, or at however many layers they tried to peel back, as like violations of like due process of law and other like constitutional law kind of principles. And then the question, like, sure, we could try to use constitutional law to protect our movements and our speech. Is that a reliable tool? Like, not really, but it's has sometimes worked for certain situations. So yeah, I'll pass it to Haz from here. Do you want me to stop sharing my screen, Haz?
No, go ahead. Keep sharing.
Okay,
Thank
sounds
you.
good.
Yeah. Okay, so next slide. So now we're going to go into the designation procedures. So unlike the 51P16, the terrorist designation, terrorist supporting designations, they're given limited due process and appeals rights. So in order to be designated as a terrorist supporting organization, which starts at section 51P8C, there are currently two parts. So the first part is the notice requirement, and the second part is the opportunity to cure. With the notice requirement, before the secretary can designate an organization, and I like to call it accused organization in this case, as a TSO, under subparagraph B, which Ari went over a few slides back, the secretary will have to mail a written notice to the organization's address, and that address is generally the whatever the organization listed on their 990 or annual return, or they sent a change of address form. And the notice will have to have 3 types of information. So the first information is that there'll be a statement saying that the secretary will designate the accused organization as a terrorist supporting organization. The second part, it will contain the name of the organizations, so not the accused organizations, but other organizations that the secretary has determined the accused organization provided material support or resources to. And then the third one is a description of what that is, of what that material resources consists of. However, it says that it has to be consistent with the national security and law enforcement interests, which is a fairly broad term or phrase. So it's unclear what that threshold is for consistent with national security and law enforcement interests. We don't know what the specific like evidentiary standard is going to be, which also bleeds into, let's say, if it's classified information, then they might not be able to disclose much in a letter as to why they're designating. And the primary way of getting that information would then have to be likely be through courts. So the next slide is the second part, which is the opportunity to cure. And the notice will have, will state like you have 90 days to challenge this TSO pre-designation. So at the close of, if your accused organization doesn't challenge it or is unsuccessful to rebut this accusation, then the accused organization will be designated as a terrorist supporting organization. Next slide. So what happens between the 90-day period? What can the accused organization do during that time period? So one way is to demonstrate to the satisfaction of the secretary that the accused organization did not provide material support or resources. And I think the key word here in this subsection is the word satisfaction. We don't know, again, what that standard means. Or the other way is that the accused organization made reasonable efforts to return to the organization that was designated as a terrorist organization, return all the resources or support that it provided, and include that in the certification. So in writing that the accused organization will no longer provide any further support to that organization. One thing to note here is that the certification will only be valid if it did not send a prior certification within the 5 past years. So by that, I mean, for example, if the accused organization provided a certification in 2025 to the secretary saying, we just withdrew all of the resources that we provided, this was by accident, for example, and then come 2 years later in 2027, you receive another notice and provide another certification saying that you took the materials back, then it won't be valid. You won't be able to rebut the designation under this subcategory of opportunity to cure. Next slide. So there was also some ways of rescinding the TSO designation. One way to rescind is the secretary determines that the designation was erroneous. So it could have been another organization, or it was sent to the wrong address, although it was on file. One thing to note here, though, you do want to keep your address up to date, because not updating your address doesn't necessarily mean it would be considered erroneous. It's still up to the organization to notify the IRS when they move to a new location. So the second one is after receiving the written certification that the organization did not receive the notice, the secretary will have to say that it was reasonable that they did not receive the notice and the accused organization satisfied the opportunity to cure, so satisfied the prior slide we went over. So they would have to satisfy either one of the two opportunity to cure requirements. And then the third one is the period of suspension has ended. So if the suspension was for 1 year, after it expired, then the organization can be reinstated. Next slide. So there are two primary ways. So let's say you try to rebut the designation or pre-designation and it was not successful. The Secretary of State proceeds to designate the organization as a TSO. What do you do at that point? So at that point, we have two avenues to challenge it. One is the administrative review by Internal Revenue Service of Independent Office of Appeals. And the other one is judicial review by US courts. Next slide. So how does the administrative review process happen? It doesn't detail much. It's just like one paragraph. And for those who aren't familiar with this board, so IRS Independent Office of Appeals is a branch of the IRS that reviews and resolves disputes over tax determinations and without litigation. And so the organization that's been designated as a TSO, they can dispute that designation by appealing to this body. And it applies to TSO paragraph B. The IRS Appeals Board will treat the designation as if it was the IRS that made that designation. So meaning that it'll have the same procedures as any other issue dispute with IRS. And next slide. The next one is the judicial review by the courts. So the district courts have exclusive jurisdiction to review a final determination with respect to organization's designation. And by final designation, the way the code currently or the bill currently defines it is final determination is either through the administrative review, or if the organization decides to bypass the administrative review, then the final determination will be viewed as Secretary of Treasurer's decision. So even if the this organization decides to not appeal to administrative board, they can still go to the court directly. This is to mean that there's no exhaustion of administrative remedies, unlike with other administrative codes and bodies. So you have two options. So you can go to the admin review, get an admin review by the IRS board, or you can go to judicial review, or you can go to admin review and then go to judicial review. And then the next slide, I just wanted to open this chart. And Mo, let me know when you have the chart opened.
Sorry. Yeah, did I stop sharing my screen correctly? No. Okay.
I think it's if you click on the link.
Okay. Sorry, I lost. Yes, I will pull that up.
Thank you. Okay, here we are. So this is just like an overview of technically what we discussed, like a comparison between the existing law and the proposed law. So it's a work in progress. It's been modified again recently, but as you can see, you can see like the distinctions between the two and who the designating agency is, the comparison between notice requirements, what it contained, the designation procedure, opportunity to cure, duration of suspension, and the challenges. So yeah, and that is it for me, and I'll pass it to my coworker Vera.
Sweet. All right. So as we just discussed, under this regime of HR 9495, if you're designated a terrorist supporting organization or a TSO, your tax exempt status is revoked. obviously, there is a notification process, as Haas just mentioned, and also an opportunity to cure. So the text of HR 9495 does not mention the blocking of property. But even so that's the case, the president is afforded wide discretion to block and confiscate property by the International Emergency Economic Powers Act, or the IEEPA. As we discussed before, Executive Order 13224 passed under the Bush administration and subsequently renewed by each administration since, most recently by Biden in, I think, September 2024. That executive order authorizes the blocking but not confiscation of property held by SDGTs, which, as a reminder, stands for Specially Designated Global Terrorist Organizations. So I'll get more into what blocking means in the following slide, but crucial to note here is that if a new executive order is passed to authorize confiscation of property, under the IEEPA, confiscation is limited to domestically located assets, and the power to confiscate is also limited to, quote, when the US is engaged in armed hostilities or has been attacked by a foreign country or foreign nationals. Okay, so next slide. The statutory language of HR 9495 does not explicitly reference the blocking of property. The blocking of assets is implemented through Federal Regs 594, which implements Executive Order 13224. As written, these implementing regulations only apply to specially designated global terrorist organizations, and not what is the new category of terrorist supporting organizations. There's uncertainty about whether there will be a new executive order or implementing regs following the passing of HR 9495 to expressly extend the applicability of these regulations to terrorist supporting organizations. But we thought we'd mention this because, for one, as Mo previously mentioned, the line between terrorist supporting organizations and SDGTs is somewhat gray. Terrorist supporting organizations, or TSOs, may very well get added to the SDGT list or another terrorist list directly. So with this caveat in mind, let's talk about what is meant by the block property for SDGTs under the current regs. So first, what property is covered? Property that is frozen includes right, title, and interest. So that would include bank accounts and liquid assets. It would include real property, and it would include all direct and indirect interests. And that latter category includes property interests that are not certain to vest, like contingent remainders, and interests that are certain to vest, but at a future date. So next slide, Mo. So secondly, what does frozen or block mean, particularly with regards to land owned by a nonprofit? Many of you, perhaps, like our organization, work with a lot of nonprofits who hold title to land. So this is somewhat relevant. So frozen means that you cannot transfer or sell land. However, if you hold title to frozen real property, it's likely you can still use and access that property, since title remains in the nonprofit's name. So there's case law interpreting these regulations, which emphasize a distinction between freezing of accounts, which is temporary, rather than confiscation of property interests, which amounts to a taking by the government and a transferring of title to the government. Confiscation requires a constitutional procedure, there's cases that suggest that the government would need a warrant based on probable cause that the property was somehow used in furtherance of a crime before entering your property and seizing physical assets. So with regard to lands, on the one hand, frozen property should allow organizations to continue to access and use land, which might be enough to allow some clients, and I'm thinking like our land back clients, some peace of mind since their intention was never on transferring or selling land in the first place. But on the other hand, the inability to transfer or sell might complicate the nonprofit's ability to access and maintain insurance or pose challenges with a lender since a lender holds a secured interest in the property. Also, if a nonprofit's bank accounts are frozen, this might pose more pragmatic on the ground issues of compensating staff or workers who steward the land. So there is a prohibition on transfer and sale, as I mentioned. And so parties seeking to transfer or sell block property must apply for a license from the Office of Foreign Assets Control in the Department of the Treasury, or OFAC. So presumably lenders will do this if they believe their interest is jeopardized by a designation of SDGT. This prohibition on transfer and sale complicates certain solutions like purchase options or rights of first refusal, since they result in transfer of title. So a third party attempting to exercise those options or rights would find such transfer null and void, unless again they are granted a license from OFAC. So this means to be most protective of land and to ensure adequate funding for adjacent costs like insurance or paying employees. If you're a nonprofit doing work that might kind of put you in that TSO category, you could consider transferring title now to another organization that is less likely to be targeted. We'll cover more on asset protection in our next MCLE, which will have a discussion on co-ownership mechanisms, easements, and other potential solutions that address this prohibition on transfer of sale. And I want to re-emphasize as I close the slide that this framework on prohibited transactions only applies to SDGTs and not TSO. So the hypothesizing right now of impact and solutions is anticipatory. So next slide. So beyond revocation of tax exempt status and the prospect that property would be blocked, here are other possible implications that come with HR 9495. So there might be heightened scrutiny of nonprofits by the United States government regarding financials, transactions, partnerships, coalitions, and operations, especially nonprofits supporting humanitarian and migrant causes. There might come greater administrative and financial burden on nonprofits. With loss of tax exemption, obviously that means that the nonprofit would be required to pay federal income taxes on their revenue. And that would come with greater bookkeeping and reporting requirements. And if the suspension does not lift, there's also a question of how to generate income moving forward, since nonprofits are usually grant dependent. And this relates to perhaps a change in donor behavior to be more cautious when it comes to grant making. So even if we or others provide education to the philanthropic sector to demystify, say, the linkage between purely political speech and speech under the direction of or in coordination with foreign terrorist organizations, donors might still err on the side of caution and be reluctant to fund any organization who speaks out on Palestine. for example. And you can see then a ripple or trickle down effect onto the nonprofits directly in self-censoring speech, right? So we might see a deterrence to fund widely and or generously. And to the extent that grants are given, they might be more restrictive so that the donor is controlling or micromanaging projects and messaging. We might see stricter compliance and higher due diligence. So there might be increased pressure all around to vet partners, grantees, and fiscal sponsees, and to track financial transactions more carefully. And I mentioned the ripple down effect being a chilling effect. And even though, as Ari covered before, the Holder case covers a very specific type of speech, right, under the direction of or in coordination with foreign groups that are designated terrorist, still nonprofits might feel a chilling effect on their own speech regarding anti-genocide, anti-war, anti-borders, and mutual aid. And, you know, even though with some greater protection and due process afforded by HR 9495, there are costs with legal fees, right, when you're doing administrative or judicial review. And then finally, I wanted to note reputational damage. Even when suspension is rescinded, the label of a TSO could be like a mark of death to funders, right? And so there's a notable case where an organization went to length to seal the classification of being an SDGT. It wasn't enough for that organization to just win the lawsuit against the secretary for an erroneous classification. They wanted that thing permanently sealed. So I will pass it off to my coworker. Is it Erica? Are you next?
I am, yes, thank you. So I'm going to talk a little bit about how this might relate to fiscal sponsorship and fiscal sponsors and fiscally sponsored projects. So in general, I think it'll be kind of, similar risks, similar strategies as other nonprofits. But because fiscal sponsorship kind of creates these close financial or even entity level ties between organizations, this could increase your risk of being implicated under these kinds of terrorism laws through the actions of your fiscal sponsor or your fiscal sponsee. So on this slide, you can kind of see the difference between Model A, B, and C fiscal sponsorships. So Model A is on the left, and that's the only one where the sponsor and the sponsee are technically part of the same organization. So we kind of are thinking of an argument that models B and C provide more distance and more insulation between the sponsor and the sponsee, depending on how daisy chaining works, as Mo was talking about earlier. So fiscal sponsees and sponsors that are concerned that their counterpart might become designated as a terrorist organization or TSO should consider opting for models B or C, just to create a little bit more legally recognized distance between the two organizations. But please note that we have also been hearing differing opinions on whether these choices actually matter, because the government does have so much discretion in who they can target and under which of all of the different laws that we've discussed. Okay, next slide, please. So for fiscal sponsors, just keep in mind the importance of keeping good records about how all of your charitable funds are being spent. These records can take a lot of different forms. It might be emails or website posts from your sponsees about how what their activities are. But ultimately, you're kind of just responsible for showing how the funds are being used, and establishing good communication and record keeping practices will go a long way towards this. Okay, next slide, please. even though this presentation is mostly focused on understanding the loss rather than sort of specific tips, we did kind of want to talk about insurance a little bit, just because there might be some misunderstandings about how it works. So, when it comes to coverage for these kinds of topics around, terrorism, TSO designation, we're thinking it probably will not be covered, but it would be good to check with your insurance companies and get clear on the language in your insurance instruments. And then also just thinking more broadly about liability. So one piece of this is kind of making sure that fiscal sponsees either have explicit coverage under their fiscal sponsors insurance or their own policies. So just don't assume that sponsees will be covered under their sponsors insurance, even if it's because it's Model A and they're part of the same organization. Insurance companies might still dispute that when it comes time to pay. And then, as I kind of touched on a little bit a moment ago, I think the second piece is just that try to see if you can get coverage for legal representation to dispute that you engaged in illegal or criminal activities. But most of the time, your insurance will probably say that they're not responsible for coverage of illegal or criminal activities such as support of terrorism. So just be aware of what's actually covered and not covered. Okay, I'll hand it over to Ari to close us out.
Awesome. Thanks, Erica. So HR 9495 is just one way that the state can target a nonprofit and take away its tax exempt status. We have a nonprofit compliance checklist that can help nonprofits stay on track of state, federal, and local tax exemption requirements. Yes, I can post that here. Oh, I think maybe that was for you, Erica. Muslims for Just Futures, which is a group that we have talked to and gotten their expertise from, has a guide on planning for government repression. And in general, SELC has a bunch of legal guides and resources on our website. Next slide. We have a little bit of time left for any questions or feedback, with the caveat that there's so much uncertainty with this bill. So it's likely we won't be able to give you a definite answer to any questions you have.
All right, we have a question from Thomas Beckett. One, it says, how have the words arbitrary and capricious entered into any cases on existing law and or cases litigation addressing the regime's current attempts at fiat rule? And two, where have the courts assigned the burden of proof on the TSO determination, to the government or the org?
Yeah, I mean, as far as the burden of proof question, it does, I mean, it seems a little too early to tell whether, like, exactly how that would work. I mean, the law says that the government has to provide evidence that that you materially supported a terrorist organization, but yeah, it doesn't really specify how much evidence. And so in some sense there is some burden of proof on the government, but if there is classified information that they can't, that they won't disclose, then that also gives them some leeway. Yeah, I don't have an answer to the first question, but yeah, I'm curious. Any other questions coming up for people? I see another one in the chat. Is anyone challenging or considering challenging the vagueness and chillingness of this? Because it hasn't passed yet, I don't think they would challenge it yet, but I imagine it would be litigated like, let's say, the first time it's actually used against an organization. I imagine they'll raise some of the due process concerns that we were talking about. I'll just name about that there's not really clarity about whether your support for a terrorist organization has to be knowing. Like, do you have to know that this is like a, a like a certain type of organization that you were helping or not? And including given the 3-year look back period of like if you supported an organization like this in the last 3 years when you didn't know it was illegal to do that, there's like there are some these arguments that would could challenge the due process of it.
There's another question in the chat. It says, any idea of the likelihood that this will move to the Senate?
I can speak to that. So it has actually stalled in the Senate of the 118th Congress, but it's likely not the end of HR 9495. We're assuming that an identical bill or worse will be reintroduced for reconsideration by the House and the Senate in the upcoming Congress. So we'll see.
There's also some state laws, similar state laws in the works, so that's something to keep a lookout for. I don't know off the top of my head.
For the recording, Ari was responding to in which states? Another question is, how can nonprofit orgs communicate with individual donors who are concerned about their giving being public or being assigned to a potentially targeted org?
I think this was addressed in the chat by Erica as well, that specifically the terrorist supporting organization designation, that's what Erica says, is only for organizations. So this is like a portion of the tax code that applies to like tax exempt organizations that are accused of supporting terrorism. And so there's not a way under that provision, like under HR 9495, for a donor, an individual who gave money from an individual bank account to like an organization, to be penalized under that provision. It's possible that the SDGT category that prohibits providing, like including US citizens from providing support to foreign terrorist organizations, like if there is a way that they could characterize that donor as falling under that category, that would be like a separate concern that is already existing under existing law, right? So we don't need HR 9495 for that concern.
And what are other nonprofit protection strategies available other than general compliance that you provided?
Yeah. So we are going to be having a future webinar, and maybe another one. The date will be determined soon, and some of it will include about nonprofit asset protection methods, successor organizations, alternative entity structures, guidance for funders, nonprofit legal compliance, and some mutual aid. Likely all of these topics won't be covered in the next one. There will probably be like 1 or 2 more sessions coming up. And please subscribe to our newsletter and follow us on social media so you're informed when those dates will be announced.
Sweet. We have a few extra minutes if anyone else has questions or feedback.
Let's just bring this question that's being answered in the chat to the recording. It says, what impact will this also have for individual donors? And it looks like Erica and Beryl had answers.
Oh, yeah, I think we said in the chat that the TSO designation is only for organizations and only for tax exempt organizations. So
Thank you. And do the Proud Boys have a fiscal sponsor? That was probably a rhetorical question, so I'm not going to spotlight anybody. But here are some other comments. Thank you. This was very helpful. Oh, okay. When will the next webinar on nonprofit protection strategies take place? That's an actual question.
Date is currently TBD. But if you're subscribed to our newsletter or our social media, we'll be publicizing it there. And I'm seeing this next comment about putting a vote for alternative entity structures as a topic for our next webinar. That is definitely one of the main things we'll be talking about in our next webinar.
We have 3 more minutes and let's see. No more questions, it seems like. 2 more minutes. Any burning questions? Let us know. Oh, it looks like someone named Danielle has a long comment. I'm just going to allow Danielle to unmute so that you can say the comment if you'd like. All right, I can read it instead. Okay, so regarding donor communication and risk, Danielle would encourage direct and explicit conversation with the donors about the risks and implications for them, help listen to what their concerns and underlying concerns are, parentheses, if name listed, worried about doxing, etc., and support them in reducing their isolation while figuring out how they want to deal with any disruptions or incidents. Listen, acknowledge, troubleshoot. Don't need to compromise your organization's politics or cave to fear, but do need to bring donors along towards brave and principled action. And then my coworker said this is very helpful. All right. And a many thanks to our ASL interpreter too from Thomas and from the SELC staff. Thank you, Elliot. And that's it, folks. Good luck, everybody.
Thanks, everyone.